Welcome to today's episode of the MondAI BAIgel podcast, where we dive deep into the intersection of technology and law. I'm thrilled to have a distinguished guest with us today, Asa Kling. Asa is an attorney at law and patent attorney, but also heads the intellectual property practice at Naschitz Brandes Amir, one of Israel's leading commercial law firms. And formerly, he served as the director of the Israel Patent Office and Commissioner of Patents, Designs, and Trademarks from 2011 to 2017. Asa, it's great you could join me and speak about AI, quantum, and law.
Thank you for having me, Michal. It's an honor.
So to kick off, are patents a good proxy indicator for technological advancement? How do they reflect the pace or direction of innovation? What's your point of view?
Well, patents are not a one-to-one indicator, but there are line is that they are a good proxy. Although we need to be careful when we measure patents as an indicator of technological advancement. For instance, to a certain degree, looking at patent portfolios is an exercise in archaeology, meaning, as we all know, patents are kept confidential for the first 18 months of their life. So when we conduct a patent search today, we're actually looking at the novel innovations of 18 months ago. And 18 months in many fields, it's a time period that a lot can be changed during that. Another aspect to be careful when measuring patent activity is how do we measure? How do we know what technology the patent applications that we are reviewing actually address? So basically, we have the traditional classification methods, the IPC, International Patenting Classification, and the CPC, the Collaborative Classification. They are an exercise in categorizing the patents, the applications into various fields, but still that does not directly indicate what is the invention about. It is a good vector to identify, but it is still not definitive. How do we drill down? We drill down, we actually search in the actual text. In the past, we would go to the actual drawers and pull out the classification cards and delve through the title of the invention, the abstract, and if that still interests us, so we continue and actually read the actual invention. Most of us just look at the drawings and just see if they're attractive or not. But nowadays, with the full text search capabilities, so we can have a better indication or a quicker indication of what's out there. But yet, it really depends on how and what we search in a textual search, as in any textual search. And when we want to measure patenting activity in the field of AI, so we'd search artificial intelligence. So any application that includes the words artificial intelligence would come up. And nowadays, maybe maybe many of the viewers or listeners are well acquainted that almost every patent application includes, okay, and this invention can be applied together with, or can be improved with applying artificial intelligence. So does that mean that is an invention that really deals with actual artificial intelligence technology? Not necessarily. So we have those caveats, but having them in mind when we measure, so we can have some kind of indication. So I call it's a good proxy, but we need to address it carefully.
So how should we manage with this, let's say, historical search right now when we want to check if there is really a pace or direction of innovation in the field of AI? Is the patent research or patent search a good tool at all, or, like you said, archaeological one?
Well, if we talk about history, so of course, if we look 10 years backwards, so I think it's a good indicator of how the technology evolved. There's a fascinating report from 2019 by WIPO about patenting artificial intelligence. I believe there was also some updates to that recently. And then they measured, as we just discussed, using various searches of the patent body. And they drew many very interesting conclusions of what kind of infrastructures were being patented over the past 10 or 15 years. What kind of applications are really popular to be patented. Just as an interesting take home, most patenting relating to AI infrastructure relates to backwards propagation networks technologies.
Okay.
And other artificial intelligence infrastructures, such as probabilistic logic, fuzzy logic, and other methods, really low numbers of patenting there. So it just gives you, okay, this is where the market is going using backward propagation rather than other technologies. So if you actually want to develop a nascent novel technology that you believe that might have better performance than a backward propagation network, maybe you want to go to a less populated area, an area which is less populated by patents. So that's one take home. And then you'll see also the applications are more of an issue of fashion.
Okay.
If you, of the bon ton, if they have an interesting splicing there of what kinds of applications, automotive vehicles, very large numbers, loads of patents, meaning they searched AI and automotive vehicles and autonomous vehicles and so forth. So a lot of activity there, whereas let's take it to an extreme, whereas applications with regards to assisting handicapped persons, really low numbers. So you can see the market talking. I mean, that's really, that shows you where the actual commercial activity was happening in those years over the past 10 and 15 years. So I think that's a good indicator because that does reflect what we recognize now, looking backwards. What has happened in the field of AI over the last 18 months, I'm not sure. Although an interesting research that I saw just a few days ago referred to OpenAI, the company that's doing the chat GPT prompt. They seems that they have a slightly different tactic or strategy with regards to patenting their technologies, and they actually do not hide under the 18 months confidentiality term. They filed several patents using in the US using the track 1 option of expedited examination. And they obtained 6 patents within less than a year, which is quite impressive for those of us who know the timeline with regards to patenting. So, and once the patents are granted, so they're out there, regardless of the 18 months confidentiality. So we see some patentees who are interested of letting everyone know, hey, these are our technologies. So there's an exception to the rule of the 18 months confidentiality, where we see a big player using a very interesting strategy of going out there and telling everyone, I'm the most innovator. So that's something that you need always also to remember, that patenting is strongly connected to commerciability.
Okay, you mentioned some trends you observe, but I heard recently your speech about quantum computing as well, AI and quantum computing. Could you share more trends you observe in this field of patenting quantum computing? It's also very innovative, extremely interesting, very novel field. How new is it?
Oh, I think it's one of the most fascinating technologies around just now, and it's very nascent. It's still in its in English way of saying it's in its diapers. I'm not sure it works very well in Polish, maybe, but it is a relatively new technology, also patent-wise. If we look, there are some reports with regards to patenting quantum computing. Same provisos, I mean, with same caveats that we need to be careful with all such measurements. But we can see if 10 years ago, we hardly saw any patenting activity. Really low numbers. So we see about 10 years ago, actually a Canadian company called D-Wave started patenting in really low numbers, few, maybe 20 patents first year in 2010 or 2010, and it was quite on a stable amount of a few tens of patent applications per year up until 2017, and there we see an exponential growth to recently in 2022. That's the newest data that we can have. We see about 300, almost 400 patent applications per year, and with many more players, and players which are more well acquainted with, such as IBM, Microsoft, Google, Intel. There are players there that were the largest player currently around is IBM, Google after that, and just after them, D-Wave, that's the pioneer that started off patenting in this area 10 years ago. Something also to understand that assists us now in the measurements of the patenting as a proxy to technological innovations in this field. Just in 2019, the IPC and CPC entered a specific classification for quantum computing. Meaning, up until then, these applications were classified either as a quantum, that can be also quantum physics, might be exploiting the physics for something else, or other combinations. So it was quite difficult to measure them. Whereas now, when we have, since the past 4 or 5 years, a specific classification, so we have more credible data, or on the other hand, it's like a chicken and the egg. Now that there was more patenting, so there's a classification. Now that there's a classification, more patents are put into that basket. But we do see a rise in that number to quite nice, considerable amounts. And we talked about the companies, so it's interesting also to have a look at from which countries the inventions originate. And there we see the US as a leader over the past 10 years with almost 1,900 patent applications, which is a nice number. But just so you know, I mean, these are really low numbers relatively to the whole scope of patent applications filed overall. But that's the numbers with regards to quantum computing as far as we manage to measure. So you've got US in the number one, and then China number two, with just under 1,000 patent applications over the past 10 years. Interesting perspective. So you see US, China in this very important field of computing, because we're not talking just now with regard about the technology itself, but it's really powerful and important technology with very high capabilities. So we see China and the US on both sides, and then we'll see Japan, Europe tagging behind. I mean, Japan with about 450 applications, and Japan just over 160, and then a line of other countries such as Australia, which is has a very active scene of quantum computing, actually also commercial-wise, a lot of activity there. And then you've got Canada. Israel is also quite active in the field, Russia, and you've got Taiwan tagging along at the end with about 30 applications.
What conclusions do you have seeing it? How is the future of quantum applications and quantum computing? Can we take some outcomes from this analysis?
Well, first of all, that the field is growing, that it's becoming a real technology, because maybe there are some skeptics voicing their ideas, questioning whether this technology can actually work. So I'll just remind us, a patent is a technological narrative providing a certain promise. Yes, so we have quite a lot of promises going around, and I want to assume that all these promising people are not falsely providing information. So, of course, the increase in the amount of patents is an indication of the growing importance of the technology in the commercial field, that it is exiting the academia, because if we look at patent applicants, we see that academia was a good large player over the past 10 years, still is, but more and more commercial players are in the field. So we see a rise in the importance of and understanding and accreditation of its importance. I do not know of any litigation just yet with regards to quantum computing patents, whereas litigation to enforcement efforts are the ultimate test of the strength of a patent. So we haven't met that test just as yet, but we have indicators that show us that the patents use more and more concrete language, use more and more examples, present really concise claims. If you review some of the claims of the later patents, really, I wouldn't say understandable, comprehensible, whereas before that, there were more of the generalistic language. You see more and more citations, meaning there's now a body of patents that you can rely on as a background bioart. There's also a lot more writing. You can cite also articles, academic articles, and textbooks, of course. So you see in the patents, you see an increase in the amount of citations. So we see an increase of the body there, of the technological body, which is an interesting perspective. And we see actually that if we look at the amount of citations in patent applications per applicant, we see the applicants from academia citing quite a lot of applications. So that's quite natural for the line of business, let's call that. But we see also applicants such as D-Wave and Rigetti and IBM providing many citations in the applications to start with, and that gives us a certain degree of confidence that there's a considerable body of art to be relied on. An interesting perspective that can be learned also from perusing the information is the note of collaboration, the notion of collaboration between countries, because I noted beforehand that we have US, China, Japan, Europe, and Europe in small amounts. But then if we look at the nationalities of the applicants and or of the actual inventors, we see a lot of collaboration, international collaboration between countries, and a lot of the innovation come as a result of US and European collaboration, which is, I think, an interesting perspective. And I guess that in most such cases, maybe the funding comes from the US, and therefore the application is colored by US colors. So that's why we see that bias towards the US, and it's not a 50-50 division between EU and US. Another interesting perspective, by way of looking at the collaborative data, is that with hardly any of the Chinese identified patent applications are collaborative, meaning China is a standalone silo of patenting in the field of quantum computing. I don't read Mandarin, so I'm not sure what's actually going on there, but the numbers are impressive, of course.
We are here to discuss AI and law. So I would like to ask you if there is any AI's impact on quantum computing in the field of patenting or from a patent perspective. Would you add something to what you said?
Well, I think maybe the question should be, how would quantum computing affect AI?
Oh, that's better. Even better.
And I'm sure that we all understand that it will be strongly affected because it will be higher degree of powerful computing. But by way of patenting, we can divide the body of patents to two. I mean, infrastructure of quantum computing, so that's infrastructure, and then applications. So we do see a large amount of patent applications directed at AI applications. I mean, patent applications directed at applying AI. And so we quite see that because with anticipation of the use of QC to implement AI. So we see numbers there. By way of the actual infrastructure technology, this is on my personal take, I've seen several patent applications addressing actual development of certain QC capabilities and design of systems using AI capabilities. But I think that's really very specific.
So one last question, not related to quantum anymore, but related a bit to your experience as a director of patent office. I have discussed it several times, and there are different views. People saying it's worth patenting AI tools, AI processes, AI applications, AI methods, and some of them say it's not worth. It cannot be enforceable. What do you think about it when somebody enters tech business, is a tech entrepreneur? Should he focus on patenting it, or it's just for the bigger firms, bigger companies, enterprises?
Well, I think the answer relies on the word you used just towards the end of your question, the word enforce. I mean, if you think that a patent that you will receive will be enforceable, of course there might be value there. Question being, can you actually obtain an enforceable patent in the field of AI? And that's a tricky question. It really depends. Depends where you file, where you receive, where do you obtain the patent. Could be a difference between the US and Europe there. And had you asked me this question 5 years ago, I would have told you that most AI related inventions will be very weak patents, but I've changed my mind over the past few years. Firstly, in view of the EPO's guidelines with regards to patentable subject matter in the field of AI, that they slightly slacked the guidelines and enable patenting AI capabilities that enable new modes of presentation of information. And that's already going beyond the invention being just considered as software as such. They identify that as a technical effect, which is a criteria for patentable subject matter in the EPO. So once that is recognized, there's a recognition that this is an important field of technology that cannot be overlooked. And we have to look also at the numbers. There's enormous amounts of patent applications in the field of AI. There's a lot of activity. So this is something that the system, it's a need that the system needs to cater to. Okay. So if the market says, this is a technology that I need protection, okay, let's see what are the metes and bounds in which I can provide an enforceable protection. And I think it's worthwhile having a good look at that, and also the IPRs and PGRs going on.
Okay, thank you very much for sharing your insights with us today. Your expertise has certainly shed light on some of the most pressing issues of the convergence of IP law and most advanced technologies. Thank you.
Thank you for having me, and I enjoy seeing you again, Michal. It's always a pleasure.
Thank you. And to our listeners, thank you for tuning in. Don't forget to subscribe, give us thumbs up if you enjoyed today's discussion, and we hope you join us again next Monday for another enlightening session of the podcast. Goodbye for now.